Well, this is volume 2, where we settle the question, is Thomas Binger competent? I have my doubts. In this segment, we're going to look at Kyle Rittenhouse's probable cause hearing. So just to make sure we are all on the same page here, in the probable cause hearing, the prosecution gets to present its evidence for why it wants to charge the accused and have a court hear it. The prosecution has all the advantages here. The defense can ask some questions, but the prosecution's evidence is going to be taken at face value. Furthermore, self-defense is an affirmative defense in Wisconsin, and therefore matters related to self-defense have to be handled at trial level. It cannot be handled in a probable cause hearing. And therefore, Mark Richards is not going to be able to make an argument for self-defense here at all. After the probable cause hearing, we'll go to Kyle's third bail hearing. The second one, I could not find anything on in terms of a video, so we'll have to go to the third one. And that's the one where John Huber flipped off the judge. Presiding over the probable cause hearing we see now is Lauren Keating. He is not a judge. He's a county commissioner. Kind of functions, I think, kind of like a magistrate would in most other states. Hello out there. I am trying to get through.
With his powerful brainwaves cradled in the warmth of reasoning, it's time for Johnnie Walker Dredd to straighten you out on a thing or two. Emanating all the way from exciting Las Vegas, Oklahoma, it's the Johnnie Walker Dredd Show.
Your Honor, this matter was addressed orally at the first appearance. The court said, file something in writing, you can raise it again, and that's the tact that we took.
Okay, kind of important. He's raised this issue before, and what he's going to be talking about is the minor in possession statute. He has an argument to claim that Kyle is not bound by it, that Kyle could carry the rifle legally. And he's already presented it once, and the court basically told him that he needs to have it in writing.
I think as to count 6, the minor in possession of a firearm, we heard the state's argument at the first appearance. I think the written submission makes it very clear. When Mr. Binger argued it, he was talking about things that are not in the statute.
I've already done a video on Binger's response to Dominic Black's attorney's motion to dismiss the charges against him because of this whole minor in possession thing. And it's pretty laughable, pretty bad. So I'm not surprised that Mark Richards is taking this stance.
The statutory language
he's cleaning out his ear, Binger is, on Zoom.
States that 948.60 only applies to people armed with a short barrel rifle or shotgun is the first exclusion.
Binger looks like he's trying to look up the statute. I think you should know this by heart.
I would submit to this court 2 things. 1, there is nothing in the criminal complaint alleging that this is a short-barreled shotgun or rifle.
And you don't even have to do that. We know the make and model of the rifle. It's clearly not a short-barreled rifle.
In fact, it says that the gun is a long gun. But more importantly, when one looks at the laundry list of charges the state came up with against my client,
a little bit of an exaggeration. There's not a laundry list. It's about 6 or 7 of them.
It's clear that if, in fact, this gun was a short-barreled rifle, he would have been charged with the felony count of possession of a short-barreled rifle, contrary to the statute, with additional penalties.
Right. Both Binger and Mark Richards agree that the short-barreled rifle exception does not apply to Kyle.
The government talked about, well, this is for hunting and things like this. There are 2 other prohibitions that are set forth in the statute. Wisconsin Stat 29.304 only applies to people who are under the age of 16.
Binger's looking it up again. I mean, come on. You should know this.
Consequently, it does not apply to Kyle. The criminal complaint lays or sets forth my client's birth date. He was 17 on August 25th, 2020. As to 29593, that has to do with hunter certification. If an individual is out hunting, And that's what Mr. Binger was hanging his hat on. There is no allegation anywhere that my client was hunting on August 25th, 2020. So,
okay, so I think that Mark Richards made a couple of mistakes here. One, the statute does say it has to be in compliance with that statute. He has not addressed that, and that left an opening for Binger. The other one is that Binger is not really hanging his hat on the hunting exception there, and so that was kind of misleading. Come on, Mark, do better.
so it does not meet the requirements of Statute 948.63. The statute is clear on its face, must be construed strictly to my client's benefit. Additionally, what the government is trying to seek is an impingement of my client's Second Amendment rights, which is not covered by this statute. It's very specific regarding when it's a misdemeanor, what it applies to, and there's basically 3 prohibitions, none of which are met. The statutory history, which is included in the brief, makes that clear. Count 6 should be dismissed.
One thing that drives me crazy about both attorneys is they're always saying it's clear, it's absolutely clear, all this, there's no question. You know what? As a judge, I would not be impressed by that at all. You know, it is not that clear. I mean, come on, we have to read the statutes, we have to interpret what the legislatures wanted. It's not that clear. Binger is really bad at this.
As to count 2, does the court wish me to do both at the same time or one at a time?
It's probably easier if we do one at a time. That way it keeps it cleaner for the record and also for everyone involved. So, all right. Are you done on as far as count 6 then?
I am, Your Honor.
All right. Thank you very much, Mr. Richards. Mr. Binger, the state's response, please.
Your Honor, counsel is correct that this court has already heard these arguments and has already rejected an oral motion to dismiss.
Well, okay, according to Mark Richards, they didn't reject it. They said they wanted it in writing. So I don't know if Binger's lying here or if maybe there's a disagreement here. Maybe Mark Richards didn't cast it correctly.
Count 6. So we're rehashing ground that we've already covered in this case and has already been decided by Your Honor. First of all, I would note that I don't think there's going to be any dispute that everything that happened on the night of August 25th is transactionally related. So the defense can file a motion to dismiss a count in the complaint today, but if the defendant is bound over for trial, the state will simply file an information containing all transactionally related counts, and we'll let a jury decide. So this is sort of form over substance here, because if the defendant is bound over, we're going to file an information with a charge that the defendant possessed a dangerous weapon as a minor, and so this is sort of moot at that point.
So he's basically saying that even if you dismiss the charge, we can find a way to get it back up again. I'm not sure I understand that argument. Whatever the case, I can't comment one way or the other. It's not because I think I disagree with Binger. It's just I'm not sure what he's really going there, and because I'm not a lawyer.
However, there is a substantial legal basis for the count 6, and that is we don't allow teenagers to run around with guns.
There's a substantial legal basis for count 6. We just don't allow teenagers to run around with guns. What the hell kind of legal argument is that? This is, again, I said this before, oversimplification. Just simply saying, well, it's just a matter of fact. It's just the way it is. That's called truth by blatant assertion. It's a fallacy. The judge or county commissioner should call him on this.
It's really that simple.
It's really that simple. Again, that's called truth by blatant assertion. It's like saying, period, end of thread.
The statute is clear. 948.60 says any person under 18 who possesses or goes armed with a dangerous weapon is guilty of a Class A misdemeanor.
Holy shit. Let me explain what happened here. Okay. 948.60 basically says that minors, 17-year-old kids, are not allowed to run around with guns. Okay. Mark Richards is saying there's an exception to that statute. 3C. And the reading of that statute makes it clear that that statute does not apply to Kyle. So what does Binger do? He goes back and reads 948.60 again. So it's like 948.60 says that Kyle can't have a gun. But exception 3C says that he can. 948.60 says he can't have a gun. Where have we heard that before? Oh, yeah.
What we do is if we need that extra push over the cliff, you know what we do?
Put it up to 11.
11, exactly. One louder.
Why don't you just make 10 louder and make 10 be the top number and make that a little louder?
These go to 11.
That's what he's doing. 94860 basically says that minors are not allowed to have guns. 94860-3C says that this only applies to hunting. Now, that's Mark Richards' claim. So you have to address that claim. You have to show that that is not an exception to 94860. And what does Binger do? He just goes back and just states 94860 again. Oh. Period. Oh, I've forgotten he tried that one. Yep, truth by blatant assertion. If you say it strongly enough, then it must be true.
There's no dispute in this case that
There's no dispute.
Kyle Rittenhouse armed himself with possesses or goes armed with a dangerous weapon is guilty of a Class A misdemeanor. Period. There's no dispute in this case that Kyle Rittenhouse armed himself with an AR-15 on August 25th, 2020.
Notice that Mark Richards was just laughing there. Even he can't believe that somebody could put forth such a stupid argument.
At the age of 17 years old. That's it. It's that simple.
That's it. It's that simple. What the hell kind of legal argument is that?
Now, if the defense wants to hide behind hunter safety regulations to try and excuse that behavior, then I'll simply quote back what Attorney Richards just said, which is, the defendant wasn't hunting. It wasn't hunting season.
That's right. Kyle's attorney is saying that Kyle was not hunting, and because Kyle was not hunting, 948.60 does not apply to him. And what do? You come back and say, Kyle wasn't hunting. You're making the defense's argument for them.
This wasn't a kid who went up north with his dad and a shotgun and went hunting for deer like last week during hunting season here in Wisconsin.
That's right, which is reason why 948.60 should not apply to Kyle. That's Mark Richards' argument. Is it correct? Maybe, but how about actually showing that exception 3C does not apply in this case? That would be a really good tactic to make. This is stupid.
This was a situation in which a teenager went running around the streets of Kenosha after curfew with a very dangerous weapon. And this is exactly why we have this law.
This is now begging the question. We're going to assume that Kyle is guilty of doing harm as an argument as to show why we have this rule in the first place and to show that the rule must apply to Kyle. So do you see that? Okay? That's why we have this rule, is to prevent people like Kyle from going out and murdering people. We haven't had a trial yet. You can't consider Kyle guilty of the offense just so that you can claim that there's a reasonable justification for having the law in the first place.
Because a teenager in this case killed 2 people and shot a 3rd. Because teenagers shouldn't be allowed to run around with dangerous weapons. Because bad things happen.
Bad things including self-defense? He is saying that if a teenager uses a gun to defend himself, that's a bad thing.
They don't have the judgment. They don't have the experience. We don't trust them with these weapons because of exactly what happened in the case.
Okay, do you have any citations for this? You're making a claim about the purpose, the intent of the law. Do you have justifications for this? Can you cite the Assembly bill? Can you cite anything?
Now, the defense seems to construe this statute as requiring that we plead their affirmative defense.
Yeah, I don't think they're saying that at all.
I don't construe it that way. There is no requirement that we allege that the subsection 3C exception doesn't apply to the defendant. There is no dispute it doesn't apply to him. No
Wait, there's no dispute it doesn't apply to him? What?
one is alleging he's complied with hunter safety regulations or has a certificate or has done the class or that this was hunting in the traditional sense of the word. This was hunting humans, not deer.
You watched John Huber going, oh, yeah. That may be the most asinine comment I've ever heard a lawyer say. He said, this was hunting humans, not deer. Well, then he was hunting. Or was he? But it's worse than that. He only charged Kyle with reckless homicide for the shooting of JoJo Rosenbaum. If Kyle was out there hunting humans, why was he not charged with intentional homicide? Lauren Keating, the county commissioner here, he should have stepped in at this point and asked Thomas Binger to clarify. Are you claiming that the defendant actually was out hunting humans that night? And Binger would have to backtrack and say, well, not really. Then don't bring that kind of shit up. I cannot believe that he said that and got away with it. Clearly, Kyle was not hunting humans. This wasn't the most dangerous game. And so to bring that up is, oh boy. Again, he'll shock me even more later when he starts getting into the bail hearing. But at this point, I about jumped out of my seat when he said that. And by the way, that comment has been repeated on social media. And therefore, words mean things. They can be harmful. The judge should have stepped in here. And frankly, I think Mark Richards should have said something here too.
This was not up north in a rural area where people are wearing safety orange during gun hunting season in Wisconsin.
Doesn't matter. Laws apply to everybody, whether they're up north or south or wearing safety vests or whatever.
And they're shooting at deer with their father or their family. That's not what happened here. So I guess, if the court wants us to put that language in there, we can do that, but I don't see that as a requirement. I see this as sort of an affirmative defense that the defense could raise. They're not going to raise it in this case. They've acknowledged it doesn't apply in this case.
Well, first of all, I'm not sure it's an affirmative defense. This makes a big difference here. So just to be clear what an affirmative defense is, with an affirmative defense, you have to acknowledge that your client satisfied the elements of a certain charge, but there are extenuating circumstances that makes him not guilty. The problem with an affirmative defense is that has to be raised at trial. The affirmative defense is a defense that you have to raise during trial. And then it's up to the prosecution to prove that the affirmative defense does not apply. I'm assuming that the affirmative defense here is going to be functioning quite like self-defense, which is the most common affirmative defense. So there is a big distinction here, but I haven't seen any evidence that Section 3C is an affirmative defense. And I would have expected that he would have produced that. But okay. Again, I'm not a lawyer, so I can't say that I'm absolutely 100% certain I'm right there, but it just seems rather odd that somebody is claiming that 3C is an affirmative defense without actually showing that that's the case.
And that would be the only exception that would allow the defendant to run around with this AR-15, and it doesn't apply here. So I think under those circumstances, as the court has already ruled at the initial appearance, count 6 is an appropriate count. It should be maintained at the beginning of the preliminary hearing, and we will certainly be filing an information after bind over to reintroduce that count no matter what.
Your Honor, just briefly in response.
Go ahead, Mr. Richards.
Where I went to law school, I was taught one was supposed to read the whole statute.
That's right. So in other words, you can't say, well, 948.60 says that kids can't have guns. Well, there's a 3C exception. Your response to that can't be, but 948.60 says that kids can't have guns. And that's what Mark Richards is saying. You have to read the entire statute. And 3C seems to provide an exception for Kyle, depending on your viewpoint. Of course, that's going to have to be settled at trial. Mark Richards is trying to get the charge dismissed. Not going to happen. Lauren Keating is only a county commissioner. He's not going to drop the charge.
You don't stop after the first sentence like Mr. Binger has. And whether it's transactionally related or not transactionally related, if it's dismissed here, they can't put it on the information. If they do, we'll file the next motion again under the applicable case law. But Mr. Binger seems to be arguing that Wisconsin statute that my client is charged under only applies to people up north or things like that. It's Wisconsin statute. It applies to the whole state. Those aren't affirmative defenses. They're saying it doesn't apply. We're not arguing that he was hunter safety. That's not what it says. He's not hunting, so that subsection doesn't apply. He's over 16. That subsection doesn't apply. And in fact, he is not possessing a short-barreled rifle. Consequently, he is not to be charged with this offense.
Okay, so if I'm Thomas Binger, I'm going to have to come up with a better argument than what I just did. What I have to show is that subsection 3C does not exempt Kyle from 948.60. And I outlined an argument for that. I also outlined an argument that defeats that argument. And unfortunately, Mark Richards is not using it. And I say unfortunately, that's okay. I'm not a lawyer. This is where the Dunning-Kruger effect is maybe taking over. But I'm a little bit concerned that Mark Richards' strategy is not going to hold up in the long term. But if Thomas Binger can't come up with a better argument than he has, he's going to lose this.
The state had filed a motion to increase the defendant's bond by $200,000 and asked the court to issue an arrest warrant for the defendant because he's violated 969.10, which requires him to update his address with the court within 48 hours of any change of address. I want to stress, as the court is aware, I think everybody's aware, this is a very unusual situation to have someone facing these types of charges who has been released from custody. Typically, in a case like this, the courts set a substantial cash bond, upwards of $1 million or more.
Well, they did. His was $2 million.
In this case, it's $2 million. That's obviously a large amount of money for anyone to post.
Yeah, okay.
In this case, Mr. Rittenhouse was fortunate that his case drew the attention of people around the country who donated money to a foundation that was run by attorney.
We set up a large bail, but damn it, somebody came up with the money to bail him out. This is so unfair. We need to increase his bail some more because he was able to make it. Man, I'm telling you, Bruce Schroeder right now is thinking, oh, you've got to be kidding me.
Let me interrupt you, if I might, for a moment. I did actually watch the video of the initial appearance, and
you can tell Binger's like, oh no, you watched that? Okay.
You already knew this at that time, and in fact, you brought it to Judge Keating's attention. That the defendant, that you did not believe the defendant was living at the Illinois address, and that he was living in a safe house, and so I guess my starting issue is, if this has already been presented and argued before Judge Keating, what triggered the motion now?
What specifically triggered it is the return that the court received. When the court mailed notice to the defendant on December 22nd, indicating that there was an arraignment on this case on January 5th, that was sent to the Anita Terrace address in Antioch, which was the address on record for the defendant. It was returned to the court, to Your Honor, on January 28th of this year, indicating that there was no one by that name at that address, and they were unable to forward it to Mr. Rittenhouse. That was confirmation that the defendant no longer received mail at that address, was no longer living there.
Yeah, he was no longer living there. You knew that.
The court is correct that I made a statement at the initial appearance that I did not believe Mr. Rittenhouse was residing at that address, but that was not, I did not know that he was no longer, that there was no one there anymore. I wondered if it was a situation where the family continued to maintain that residence, but they were spending their nights in a hotel or at someone else's house. That's not unusual, but I didn't know they'd moved out entirely. And ultimately, whether I know this or not is not the salient factor. The 968.9.10 requires the defendant to notify the court. This is a court order. The court is the one who issues the bond, not me. And even though I had suspicions the defendant might be spending his nights in a safe house or spending time elsewhere, I didn't know where that was. No one notified me of that. I still don't know where that's at. I have.
Good. And you know why? Because if you know where he's living, all of your BLM buddies will know where he's living in short order, and Bruce Schroeder knows it.
No idea where the defendant is spending his time. The court has no idea where he's spending his time. And that's a very unusual and dangerous situation when you have someone facing these types of charges in this case. As I was saying, this is a very unusual situation to have someone facing these charges who's out there free on bond. And what makes this even more unique is that the defendant has no stake whatsoever in that bond.
Yeah, Judge Schroeder's not going to care whether the defendant has a stake in it. You set a certain bail amount, and he was able to come up with the money. It doesn't matter if people raised it for him. I mean, what the hell kind of argument is this? We should raise the bail amount because he was able to make it. Well, the purpose of having a high bail is not to prevent the defendant from being able to make it.
There's no financial incentive for him to comply with bond. He's posted none of the money that's been the $2 million. In fact,
yeah, well, he can also be arrested if he doesn't show up. That seems like a pretty strong motive to be there.
There's some sort of dispute going on right now between Attorney John Pierce, who posted the bond.
I don't want to get into that. I don't want to.
Well, Your Honor, but I think this is salient because
the bond is up. We've got the cash here, so.
Yeah, Schroeder goes, dude, what the hell is this? You wanted a $2 million bail. We did it, and he came up with the money, and you're pissed off? Shit.
I don't care about a feud between a lawyer and somebody else.
My only point, Your Honor, is that from the defendant's perspective, what incentive does he have to comply with the bond?
Well, let's see here. He's here. He showed up, so he must have had some incentive. That's one thing that Schroeder is looking at. He's saying, wait a minute, the defendant's sitting right next to the attorney, and he's in our hearing. So there must have been a reason for him to show up. And yeah, it's called not wanting to go to jail. So this whole idea that, well, the defendant has no incentive, he's shown up at 3 hearings so far. No, 4. Why? If he has no incentive.
Incentive does he have to ensure that the non-monetary conditions are met here? And there's a very small incentive here for him to do that. When facing charges like this, there's a very large incentive for him not to comply, not to come back to court.
There's a very large incentive for him not to come back to court. And he's talking, and Kyle is right there in court. Oh, man. Now, of course, this is on Zoom, but he's sitting right next to his lawyer. I mean, come on. And, of course, Schroeder is like, oh, I can't believe I have to listen to this shit.
Because there's a great risk here. He could be spending the rest of his life in prison. So when we look at that context, there's very little wiggle room here. The defendant, I think, needs to be kept on a very short leash. We need to make sure that he's compliant with every single part of that bond, which is why I filed this motion. And the defense has admitted it. There is no dispute from the defense that they have not complied with 969.10. There is no dispute. They've acknowledged he hasn't resided at that address. And I want to
wait. Well,
whoops! First mistake. Well, actually, he's made a bunch of mistakes, but here's his first one that Schroeder is going to call him on.
Is that what the statute says?
Nice.
Because when I looked at the statute, which I do periodically, but this one certainly brought it back to my attention again. And actually what it says, it's 969.03 subsection 1, which pertaining to people charged with felonies. And it says the judge may, in addition to requiring a cash deposit.
Binger, you should know this stuff. Come on, why are you having to look it up?
Impose conditions which will secure appearance for trial. And under subsection B, the statute says place restrictions on the travel, associations, or place of abode. Now, I do that with some degree of frequency with people, and the percentage would be very low, would be in the low single digits. But if I get somebody who's already out on bond, for example, on a 4th DWI, which I'm really quite uncomfortable with, I will put them on a house arrest, and we require their address. They have to be there. They're allowed often to go to work, but otherwise they have to be in their house. That's a restriction on the place of abode, and it's authorized by statute. You didn't ask for that at the first appearance, and Judge Keating didn't order it. So I don't think it's correct to say that the defendant is required to live at the Antioch address, actually, or any other address.
That's right. What do you do if a person's homeless?
Well, according to Wisconsin Statutes 969.10, Your Honor, a person who's been released on bail or other conditions shall, this is mandatory, shall give written notice to the clerk of court of any change in his address within 48 hours after the change. This shall be printed on all bonds, which it was done here. That was not complied with.
Yeah, that's right.
Not complied with that.
I agree with you there. But your statement was he wasn't living there and he was required to, and I don't think that's an accurate statement.
And I think
having an address for the receipt of court notices, which may come in for a variety of reasons, change of date or whatever, having an address, and in fact, when we tell these people, when they give us an address, we say, and some people, for example, are homeless, or they're staying with aunts, 2 nights here and 3 nights there, and rather than locking them up, we say, here's you have to give us an address, and you're responsible for any mail that's sent there. And that's what I interpret the necessity to give an address to mean. It does not equate with placing a restriction on the place of abode, which is specifically a feature in the statute that the court can order, but I couldn't find any record that that was ordered by Judge Keating or that you requested it.
Okay, Binger, get a clue. What the judge is saying is that while he may have technically violated the bond agreement, it's not that big a deal. You need to now re-strategize. You're not going to get what you want. And now, if you continue going down this path of lusting after throwing that kid in jail, you're not going to look good.
I agree with what you're saying, Your Honor, and I think the distinction you're making between an address and a place of residence is an important distinction in the statutes, and I do understand that there may be a difference between those two things. Ultimately, Your Honor, I think this is a case where it would be important for the court to know exactly where the defendant is living. As I said, this is an extremely serious case, and I think that it's important that we don't know a P.O. box. We know exactly where the defendant is because of the risk of intimidation to witnesses, the risk to the community. And ultimately, Your Honor, I want to make it clear to anyone who's watching this that the Anita Terrace address, which was on record for the defendant, is no longer his address. It is not associated with him. There is someone new and innocent who's residing there and should be free from any contact, mail, people bothering them, anything like that. You know, the defense is going to argue and has argued in their written submissions that they need to keep the defendant's whereabouts confidential because of fear for his safety. Now, someone new has moved into the defendant's former apartment, and that person is in jeopardy.
Binger, you're an idiot. I can't believe that you're making this mistake. You're gutting your own argument. And almost everybody has caught this. How can you not catch it? You're basically making the defense's case that Kyle faces serious bodily harm if people find out where he's living. Because after he left, the people who moved him into his house are facing serious bodily harm. That's your claim. And this is where Binger just totally loses the whole point of the strategy. Look, if you're wanting to get a bond increased on a defendant, you have to look at what the bond is designed to do. It's designed to make sure that the person shows up at all future hearings. He's been showing up, is not going to hurt other people, no evidence he's hurt anyone, and is not going to contact the families and the witnesses, which there's no indication of it at all. Kyle was very thoughtless in leaving that home because it might hurt the people that moved in. Doesn't address any of those three. This is an attempt to paint the defendant in a negative light, but that's not what we're here to do. We're here to demonstrate that the defendant needs to have a higher bond or thrown in jail because of those three elements. And this is not going to work. And in so doing, you've basically admitted to Judge Schroeder that Kyle's life is in serious jeopardy. And that is all that Bruce Schroeder needs to keep Kyle's address private. You are basically saying that Kyle needs to keep his current address private. I cannot believe that a professional attorney went into this hearing with this strategy. I think even Kimberly Motley has looked at this and said, oh, wait a minute, that doesn't make any sense. We're supposed to be here to show that Kyle's fears are overrated. And now we just got done saying that the people who moved into Kyle's house face serious threats. Oh, geez.
That person is at risk from the things that the defendant is fearful of. And as recently as 20 days ago, on January 22nd, the defendant misrepresented. He lied about his address to this court by signing a bond with the Anita Terrace address on it, knowing full well that was no longer an address that he lived at, no longer an address he gets mail at, no longer an address that he's associated with in any way. And in fact, someone new is there. And if there's anyone out there that wants to try and find Kyle Rittenhouse, that might be the first place they look, and that person is potentially in jeopardy.
Right. So we need to keep Kyle's address secret. So Kyle's decision not to put his real address on there was justified. That's what you're saying. Nice going, Binger.
So that was a very dangerous and irresponsible thing, a callous thing to do.
Dangerous, callous. Yeah, okay. Let's paint the defendant in a very negative light, but that has nothing to do with bond conditions. The kid is facing 2 counts of murder and attempted murder. And you're going to try to get his bond increased because he was callous? That's your argument? He's a meanie? He was thoughtless? Okay, I don't know.
And that's one of the things I wanted to bring to the court's attention so we can fix that.
Well, how do we fix it? We fix it by having Kyle give the court his address. And you got done saying earlier that, well, this is really about the court's issues, not ours. It's not our law. Okay, and that's going to give Judge Schroeder a perfectly good reason not to give you the address. As long as the court has the address, Schroeder is happy because you told him earlier that it's really all about the court, and these rules are violated the court's deals, not Binger's.
And make sure that whoever's in that apartment is safe and isn't going to be bothered to the extent anybody's out there trying to bother Mr. Rittenhouse. But more importantly,
Mark Richards, he can't believe this. He probably had this all lined up, this argument as to why Kyle faces serious bodily injury if people know his address. And then Binger took care of that for him. I mean, it's pretty bad when the defense attorney is crossing off elements off his page because the prosecution is making his case for him.
we've got a bond violation here. 969.10 has not been complied with, and there's no dispute about that.
Okay, but you have to also show that the remedy for that can only be increasing the bond amount or throwing him in jail. And that's not the remedy that Bruce Schroeder sees. Judge Bruce Schroeder sees the remedy as just getting Kyle's address. Kyle has been showing up at all the hearings. So if your real big beef is that the court doesn't know his address, okay, we'll just have Kyle give us the address. Fixed. Problem solved. And you should know that that's where Judge Schroeder is going to go with this.
The defense has acknowledged that. They've acknowledged that they failed to update the court with his address within 48 hours. He moved a couple of months ago, and they never bothered to update the court. Now, back in November, I had an email correspondence with Attorney Chirafisi, who was representing the defendant, about this very issue and whether or not they could keep his address confidential. And I advised Attorney Chirafisi to file a motion with the court. That is the proper procedure, Your Honor. If they confidential, they should have filed a motion. They should have filed that motion the moment Mr. Rittenhouse left the Annie Harris residence. They should have filed it with this court and asked the court's permission. But instead, what they've done is gone ahead and done it unilaterally without any court authorization, without any notice to anyone here. They've acted independently. And frankly, this is the latest in a long line of incidents where I think the defendant is essentially thumbing his nose at the court's requirements here.
Well, wait a minute. Long line? This is one of a long line of instances where Kyle is thumbing his nose at the court? Like, what else is there? I'm sorry, but going to Pudgy's is not. Wearing a t-shirt that has the F word on it is not. Getting selfies with people that you don't like is not. This is the only violation of any bail hearing that has occurred so far. So how is this a long line? And by the way, Schroeder knows this. Schroeder's just shaking his head like, oh yeah, long line, my ass.
Here, and it's very alarming when someone is facing these serious charges to go to a bar and drink, to wear a t-shirt with a profane message on it, to flash white supremacist signs, to move away from this address, put someone else at risk, and then refuse to disclose your whereabouts on a case like this. These are very troubling things.
No, they're only troubling to you, okay? That's your opinion. You don't like him going out drinking at a bar? Well, gee, how about putting that stipulation in the bail agreement? You didn't. If him going out and drinking beer in a bar was such a serious affront to you is so alarming, as you say, why didn't you put that in the bail agreement? You didn't. You didn't even bring it up. And, hanging out with people and having a profane t-shirt, really? Really? Again, bail is designed for what? Make sure that the guy shows up in court, he's here today, that he hasn't hurt anyone, wearing a t-shirt, doesn't do that, and doesn't try to contact witnesses or victims or whatever. And he hasn't. So, what is Schroeder thinking? I tell you right now what I would be thinking. This dude just wants this kid in jail. He wants this kid in jail so bad he can taste it. And now he's drumming this stuff up to try to get him in jail. You would have been better off not bringing up the whole Pudgy's thing and instead focusing on the address issue. At least he violated that agreement.
Now, I'm aware of the fact that under 969.035, the state could ask the court to revoke the defendant's bond. In fact, there was a protest last weekend. People in the community asking us to do that.
Oh, man, don't do that.
No, I don't want to hear about protests. I don't want to deal with what media reports that are inaccurate. There were some very careless reports in the paper the other day after I issued the restriction on associations. The media nationwide, I guess, portrayed it that I had prohibited the defendant from associating with white supremacist groups. There's nothing in the order about that. It would certainly be encompassed within what I ordered.
Gee, does the national media ever lie? Mm-hmm.
But it was not limited. There was a report the other day locally that said that I think you had issued a warrant for the defendant's arrest. And, I think that's what it said or something. The DA's office issued a warrant for his arrest. And this kid, look, I want to have a fair trial in this case.
Oh, no, a fair trial. Oh, damn, Binger's like, damn it. There goes my strategy. Ultimately, in the end, the judge recognized that you were trying to put in some political pressure here, and he's having none of it. Get a clue. Don't try this tactic.
And I want everybody, I mentioned this in my earlier order, I want everybody to act in a way that maximizes the possibility of fairness in this case. Fairness to everybody who's involved. And I don't want this case is not going to be decided by demonstrators of one type or another, and frankly, it's not going to affect anything I do, and I don't think it's going to. I don't want to whip stuff up so it affects a fair trial in this case to decide it strictly on the evidence. So I don't want to hear about a demonstration last weekend, okay? Because if we do that, then tomorrow we'll have a demonstration by people who view things differently, okay?
And that's why I had filed a motion for a gag order in this case, which is still pending on all the parties, because this should not be something that's tried in the media.
Demonstration? How do you gag a street demonstration?
The gag order was filed when Attorney John Pearson interviewed on national news.
He keeps trying to bring up the other attorneys. I don't think that Schroeder really cares about that kind of stuff. This sounds like a little petty squabbling amongst lawyers.
Case, Your Honor, that's my But
my point is, the less anything other than just strictly discussing what the facts and the evidence are occurs, the more likely we are to have a trial that's fair, to the defendant, which is his constitutional guarantee, and to the public, which is my responsibility.
So Schroeder is basically saying, I don't want to hear about pudgies, okay? That was not a violation of any bail agreement, so don't bring that up. I don't want to hear about any Proud Boys. That wasn't a violation of any bail hearing, so don't bring that up. We're going to worry about the facts and what the law says, okay? When he was released on bail, there were certain terms of agreements, and as far as we can tell, he has complied with all of them except for this one.
So,
Understood.
I interrupted you. Go ahead.
I was just making the point, Your Honor, that under 969.035, the court does have the ability to revoke bond in a case like this. However, there is a burden on the state proved by clear and convincing evidence that it's necessary to protect the public or prevent the intimidation of witnesses. And at this point, I don't believe that I could meet that burden, which is why I didn't ask the court to revoke the bond here.
Oh, well, you're such a nice guy. Oh, my God. What a swell dude. He's not asking the court to revoke his bond. Well, he wouldn't have gotten away with it anyway.
However, I do think that there is a basis with the course of conduct that we've seen here for the court to impose a consequence for the defendant's violation of the bond, which has been admitted by the defense, to increase his bond by $200,000. And until he does so, I think a warrant should be issued for his arrest. Now, I don't know how long it's going to take him to post that money, but I think that that's something that needs to happen here, because otherwise there's no consequence on it.
Actually, there's a statute about warrants. There's a statute about warrants in these cases also.
Binger's like, what? What? Statutes about warrants?
969.08 subsection 5A.
Head over to your computer, Binger, because obviously you weren't prepared.
A court may issue a warrant for the defendant who has already been admitted to bond only if the district attorney complies with 969.08 subsection 5A, and that requires, number one, that the defendant was released on conditions, which is the case here. Number two, alleges the defendant violated a condition of release by committing a serious crime, which I haven't seen any allegation of that. And number three, that the district attorney provides a copy of the complaint charging the commission of the crime. So you're short on two conditions in terms of my issuing a warrant. Now, tell me if I'm reading that statute wrong.
No, you're not, Your Honor.
Gee, then maybe you have no argument then. Look, you're wanting the judge to arrest the defendant, and there's a statute in there about that. You might want to read that first before you go and embarrass yourself in front of everybody.
I'm not alleging the defendant has committed a serious crime. I'm simply alleging he's violated the conditions of his bond by...
Okay, then why are you here? If you're not alleging that he violated a serious crime, and that's what the statute says, why are you here?
Failing to update his address with the court.
Well, but it says, let's get the exact wording.
The judge is thinking, this guy wants the defendant's bail raised so high that he can't make it, so he has to stay in jail. And guess what? He can get hurt there.
Yeah, it says, if the court, this is subsection B, subsection 1, 969.08, subsection B, subsection 1, if the court determines that the state has complied with paragraph A, the court may issue a warrant. That's the limitation on the court's authority to issue a warrant, is if the district attorney has complied with paragraph A. And paragraph A is what I just read, and you're missing two of the three ingredients that would be required to empower me to issue a warrant.
Wah, 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 wah.
Unless I'm reading that wrong, and I don't think I am.
I understand, Your Honor. I am asking the court to increase the bond, however.
I'm giving up on that one. Okay, I guess we can't have him arrested. Doggone it. Can you at least raise the bail?
Go ahead.
Thank you, Your Honor.
Is that it?
Oh,
Mr.
That's
Richard?
all I have, Your Honor. Please, Ms. Motley, and maybe Attorney Art, also on behalf of the victims, would like to give a brief statement as well. And I would ask the court.
You know that I don't permit the use of the term victim before adjudication in this or any other case, and I haven't for years. So please don't use that term. And I know this is an awkward situation, but I do not permit the terms victim or alleged victim unless and until there's been an adjudication.
And he's probably told Binger this a number of times. I mean, keep in mind, Binger's gone up in front of this judge probably 100 times. Maybe that's an exaggeration. But he certainly knows. He's going to try to use the word victim as much as he can because this is all about propaganda. The judge called him on it.
So these are folks who are speaking on behalf of the families of the deceased?
Your Honor,
Yes.
John Huber is the father of Anthony Huber, who was killed by Mr. Rittenhouse.
Now, if I was Binger, I wouldn't have these people here in the hearing at all. They do nothing but hurt your cause. Why do we have to have these people here? Are they going to bring in some testimony, some evidence here that would help me make a decision on whether we should increase the bail? No. They're only going to embarrass themselves, and there's no point in this. Binger, if I were you, I would leave these people at home, if you can. I mean, maybe the court requires it. Well, we're going to go ahead and skip ahead here because the inanity and hilarity of what they say is all good for another video.
He was not put under condition of living at a specific address. That could have been done. The district attorney apparently was aware of what he now refers to as flying the coop, was aware of that situation back then, and he didn't ask for conditions on place of abode, and Judge Keating didn't order it. So there's no change in circumstance there.
Listen to what the judge is saying. Listen to the tone. Does this sound like a person who's going to have Kyle arrested? No chance in hell. Binger should recognize this. This is a lost cause, and the best thing to do is just back out of this. But what does he do?
I do not believe it's proper to issue a warrant. I don't think that would be lawful. No matter what feelings anybody has, I took an oath to uphold the Constitution and follow the laws, and that's what I'm going to do. And it's sad that this is getting at the level it is.
In other words, it's sad that you're taking us to a political level, Binger, that you're trying to have a kid thrown in jail at all costs, regardless of what happened. He's not fooled.
But I can't help that. I will tell you that the violation of not, well, most of the people who are out on bond, we don't know where they are. There are people who are out on bond who are they're business people. I've had cases where people they do international business and they fly all over the world while they're out on bond, and there's nothing prohibiting them in that bond.
In other words, Binger, the judge doesn't think that this is any big deal. Figure that out. You got to understand this.
This is a border county. A significant portion of the people we have out on bond are living in Chicago or one of the other collar counties and are in and out of Illinois every day. So we don't have these restrictions on travel except when the judge, following the statute, puts an abode condition on. That was not done in this case. So he didn't violate anything like that. I don't have the authority to issue the warrant the district attorney is talking about, and I don't agree with his analysis of what the circumstances, or I should say the procedure for getting the bond changed. I get people in here and I do change their bonds. And then I tell them to post it by a certain time or they have to report to the jail. If they don't report, that's when the warrant gets issued. But to issue a warrant now for a defendant who's appeared at every hearing, that would be I'd be breaking the law, and I'm not going to do it.
So in other words, he really has sniffed out Binger's attempt to get Kyle arrested at all costs.
I disagree with your statement that bail is a privilege. Bail is a right in the Constitution.
He's talking to Motley here. I think Motley's only real purpose is to make Binger look a little bit smarter.
And he's posted the bail that was set. Now, he's in violation of a condition about updating his address.
And Binger's like, oh, here it is. Here it is. I'm going to get Kyle in jail. I'm going to get him in jail.
Sorry,
And
actually, is this all to me?
I'm talking just generally.
Okay, got it.
I'm talking to everybody.
Be quiet.
I'm talking to everybody. Actually, if he'd have left a forwarding address, that probably would have been full compliance with the bond order, because we're interested in an address where we can send notices to the defendant to appear for a hearing or whatever the case may be.
And that would actually be Mark Richards' address. Kyle is here today because Mark Richards was notified about this, and he told Kyle.
He apparently didn't leave a forwarding address. At least that's the evidence that was returned to the clerk. So he's in violation. I can tell you, and I talked to the clerk about this yesterday to confirm what I thought. There are a very, very, very high percentage of people who are out on bond who, she routinely asks after a hearing is done, are you still living at the same address? And I would estimate the number of cases where the person says yes is over 10%, maybe significantly more than that, where the people say, yes, I've got a new address, and they haven't notified the clerk. They're in violation. I've never jailed one of those people. I've never heard of any other judge jailing those people. I have never seen a bail jumping violation based on one of those things. I've never seen the district attorney bring anything like that into the court.
Oh, wow. And he's basically saying, hey, Binger, I've been at this for a long time, and what you're requesting from me is ridiculous. It is ridiculous. You want a kid thrown in jail because he didn't leave a forwarding address. And no district attorney has ever asked me to do that before. Why are you doing it? And Judge Schroeder knows why.
We amend their address on our records, and they might get barked at a little bit about violating the court's order. But that's the extent of what happens, and they don't get a raise in their bond of 10% raise in their bonds. I can't recall that ever happening. I'm sure it hasn't. He didn't. So he is in violation for not updating his address, and that has to be addressed going forward.
In other words, fixed. As he mentioned before, how do we fix this? That's how he's going to fix it.
But he also, as Mr. Richards has pointed out, he appeared on the last hearing, which was the return notice. He was there at Mr. Richards' office. So I'm assuming he came from wherever he was to Racine to attend that meeting, and he's here today. So I'm going to deny the motions.
Okay, Binger, at this point, quit. Give it up. You've already been exposed as somebody who's overzealous. And now, if you continue to press this, you're going to start to worry the judge a little.
I do think that I understand the concern, and my heart goes out to everybody who's involved. This is a terrible thing, and that's one of the reasons I feel so strongly I want it to be handled peacefully and fairly and impartially, and part of that, that's a small part of it, is the risk that there would be the kind of concern that the defense has talked about in terms of the safety of the defendant. And quite apart from the interests of the defendant.
By the way, the safety of the defendant that you, Binger, basically substantiated by opening your big mouth.
After what this town has been through in the last 6 months, I don't want any more problems. The police don't need any more problems. We don't need to have people's safety in jeopardy in any way. So I think that the desire that the bond or that the defendant's address be kept from public scrutiny is a legitimate one. And what I'm going to order is that the actual physical location of the defendant, and it will be his place of abode. If he's going to remove from there, he'll have to follow the bond condition and give us the exact physical location of his place of abode.
Binger's going, yes, I'm going to have it. I'm going to have the address. Call my BLM buddies. I'm bringing the address home, babies.
And that is to be given to the deputy clerk working in this court.
Mm-hmm. Yeah.
Who will keep it privately. It will not be part of the public record. It's to be given to me. It'll be held the same way. And it's to be given to whomever the sheriff designates as the person who would be responsible for full knowledge of the whereabouts of the defendant.
Binger's like, wait, I don't think that's me. Huh?
And that is to be kept secret by the sheriff's office. So, is that clear, Mr. Richards, what's required?
Richards says, oh yeah, perfectly crystal clear.
It is, Your Honor. You and your clerk will have that by 5 o'clock today, and I will have it to the sheriff's department as soon as I'm told who to designate it to.
Okay.
Your Honor, I would also any information be shared in our office too, please.
No.
A couple of things. Mark Richards, right at their moment, he goes, no way. And then Judge Schroeder goes, no. Now, why did Schroeder go, no? Because Binger has been spending all this time trying to get Kyle locked up. He doesn't trust Binger, not one lick. And Binger should recognize that. He needs to repair the relationship. He's not going to.
The district attorney's office, and the answer is no. That has nothing to do with you or your office.
It does. Whenever somebody says, oh, this is not really about you, it's not that we don't trust you. They don't trust you.
I think the sheriff would be your right arm, left arm, whichever is preferred, in discharging anything that would need to be done. And they're not to share it with you unless you offer good reason. And it's not that I don't trust you.
It's not that I don't trust you. No.
I think that the less of this, the safer everybody is. As I said, you remember what went on 6 months ago here? I've got 2 broken windows here, right here in this courtroom.
Get a clue, Binger. He doesn't trust you because he thinks that you're going to give the address to BLM.
The doors are all still covered with plywood. A good share of the community is still boarded up after millions of dollars of damage, property damage, and this ghastly event occurred. So no, I don't want anything that might kindle further violence. And so no, it's not a reflection in any way on you or your office.
Now at this point, Binger should realize that this is a lost cause. What I'm going to do is come back and say, you know, Your Honor, we appreciate your concern for public safety here. I I would like to draft another argument for you. Would you be receptive to that? Or something along those lines. But you got to get out of here. You have pissed off this judge, and he ain't going for it. And the last thing he wants to hear from you is just more and more argument. And guess what you're going to provide him?
Your Honor, I hope you're not suggesting that sharing this information with our office is somehow going to lead to further violence, because we would not be in any way contributing to that. But our obligation is to help monitor the defendant's bond.
Yeah, that's exactly what he's suggesting. Okay? That's exactly what he's suggesting. Get a clue.
Conditions, and without knowing where he's at, that becomes very difficult. If I'm to file a charge of felony bail jumping, for example, for the defendant violating his bond, and I don't know where he's at, that makes it pretty difficult. And if the court has placed the burden,
call the court
and
call the court,
criticize me for not doing so in the past, then I feel like I need to have this information. And certainly, no one on this Zoom call needs to be reminded of the events of 6 months ago.
Now remember, Schroeder said you could call the court. Binger is so wrapped up in this argument that he even ignores the judge. He doesn't respond to the judge's comment. He just wants to just go, go, go. He's a little bit out of control at this point.
We have the loved ones of two deceased and a victim who was shot in the arm by the defendant that night. So
please don't use the term victim.
Whoops.
Mr. Grosskreutz was shot in the arm.
And Your Honor, if Mr. Binger wants my client, if Mr. Binger wants my client to appear on what he's going to do next, which is issue a felony bail jumping, send it to my office. He'll be in court the next day. This posturing is not serving any purpose at this point. The court has ruled.
Yes. Mark Richards is very straightforward. He comes off as sometimes a little bit cranky, but it's hard to deny what he said. The court has ruled. Binger should recognize that. This is a lost cause at this point. You need to escape. You need to bow out gracefully.
Your Honor, it's not posturing. This is standard procedure in all criminal cases that everybody knows where the defendant is. This is highly unusual for this to be withheld under seal. The court has ruled that it can be sealed from the public, but we are not the public. We are the prosecuting agency. We are the prosecutors on this case, and we have a very...
Look at Judge Schroeder. He's like, when's he going to shut up? When's he going to shut up?
Important right to know this information as the prosecuting agency in Kenosha County. And I have never heard of a situation where this information has been withheld from our office.
Well, you have now.
The Sheriff's Department, you're right, is a law enforcement agency, but we work with them, and to withhold them from giving to us, the court not giving it from us, to cut us out of that information is not appropriate here. Our office is headed up by the elected DA, the chief law enforcement officer in this community. This is a murder case, and we are entitled to this information, Your Honor.
At no point is he telling the judge why he needs it. He doesn't tell him, we need this address because of such and such. His argument is, well, you always get it. This is just traditional. We're entitled to it.
Your Honor, we have never been denied this information in any case that I've ever heard of.
Well, now you've heard of one.
If the court is aware of a case in its history where you've not shared this information with us, I would appreciate you sharing that with us, letting me know what case that was.
Oh, man, if I'm the judge, I'm livid on that one. Oh, I have to prove to you that you're entitled to this?
Because this is highly irregular. We have a right to know this. I would argue the public has a right to know it as well. I understand the court's ruling from sealing it from the public.
Well, if the public has a right to know it, then you can't seal it from the public. And you don't have a right to it, right? The word right has a distinct meaning in law.
But our office has a responsibility to enforce the laws, enforce the bond here, to file bail jumping charges if there's a violation of that, and we cannot do our job without this information.
Yeah, the sheriff can enforce it just as well. And unlike you, the sheriff isn't interested in getting Kyle thrown in jail at all costs.
If the sheriff can keep on top of this as to whether there's a violation, that's where most of your information, when I was district attorney, and I know it's been a long time, but I didn't have any investigative staff, except one investigator, which I won't go into, but the sheriff's department was in charge of reporting bond violations and the like to us, and I think the same situation is true now.
Okay, at this point, he's heard your bullshit. He ain't buying it. Bow out. Get out of this.
Hearing's over. Thank you.
The hearing's over. Get a clue, Binger.
The defendant doesn't reside in Kenosha County, Your Honor. The sheriff can't help me.
Thank you. Thank you.
Good afternoon.
Good afternoon.
Okay, so how did Binger do? He blew it on every point. And in fact, in this hearing, he did nothing right. Didn't come in prepared. If you're going to have the defendant's bail revoked, go over the statutes. Make sure you know what those say. I mean, Schroeder knew it. And make sure you know your purpose. Your purpose there is to get Kyle's bail increased. Well, what's the conditions for bail? Why do we have it? Hit those points. Don't lose sight of that. Instead, you tried to smear his character. This is just a short-term feel-good moment. So yeah, you made Kyle look like he's thoughtless and careless by not notifying everybody where he's now living, because these people are going to move into his house and they're going to get attacked. But by doing that, you gutted your entire argument. Also, know when to quit. The judge was not buying your argument at all. And now you sat there and begged him for the address. Just reaffirms to the judge that his decision to withhold the address from you was the correct one. I don't know. I don't know how this guy got his law degree. I really don't. Now, this is Monday morning quarterbacking. I'm not a lawyer. But when you watch your quarterback throw 5 interceptions by halftime, it's okay for people who are not quarterbacks to say, gee, I don't think he's doing very good out there. I don't have a law degree, but I can tell when somebody's not doing well. And Binger, you got your ass kicked here. Like my video, subscribe to my channel.